anything to anyone.
Okay. Sir, what I was asking, do you have to share any PPT or it will go extempore? Is there any PPT you have to share?
Yes, I do. If you don't mind,
no, Tisha, please make sir co-host so that he can share the PPT. We are still having 10 minutes. So meanwhile, you can check the working of the Zoom meeting. Tisha?
Yes, ma'am. Yes, he was made as a co-host also.
Sir, please check whether you are able to share your PPT or not.
Okay, so Vandana, just let me suggest this. Why not? Why don't I just manage to share the screen while we go along, right? And afterwards, I might send everything to you, right? So I don't think it will be a problem for me to do both things. You know, it's not that easy, speaking and sharing at the same time. I don't know, right. I'm pretty much handy with that. I'm sorry, I joke a little, right? So please don't mind. Okay, so
whatever convenient to you, sir, not an issue for us. Means we just wanted to see there should not be any technical glitch. So just check whether you are able to share your screen or not.
Okay, fine. Let's see if we can do this quite easily. Just a second. Okay, so good. Are you seeing this?
Yeah, good. We can.
Okay, so please don't mind. I've tried to have this done in a quite. So I used the symbol of your university as you are seeing here, right? Is this okay? Because I cannot read. It is fine. Okay, then I'll just try at a certain point, because of copyright issues, I will not share images, but I don't think it's a problem for me to portray Google here, for instance. I will do like this and maybe share one or two pictures like this, you know, without putting them on my presentation straight, and then we will finish this and go back to the thing. Are you seeing well the whole thing? Zubair?
Yes, sir.
Is this fine? Okay, yes, so I'll stop sharing now. Yes. I'll stop sharing now, right? Sure. Good. Thank you. Fine. If you don't mind, I'll just so we do have 5 minutes. We are not on air yet, right? We are not broadcasting live, or are we?
We are recording. Tisha, I think you can stop the recording for some time. The moment you can.
Okay, Vandana. So you tell me whenever you want me to begin, right?
Within a minute. Yes, sir. We can start within a minute. Participants are joining. So, no Tisha, we can start.
Queenie ma'am has joined.
Sorry, are you talking to me, Zubair?
No.
We are looking for our faculty, and
just no, don't worry. I'm not hastened at all. I do. My time is yours. I can stay here for how long as it takes. So don't worry about that. It's a pleasure for me. And also, Tisha, if you feel like, or any other person from the audience, if you feel like interrupting at any time and asking questions, I think that digital means and this online thing, it is good, but it's difficult to replace. I mean, how vivid live sessions are, right? So,
sir, one thing I would like to know, like after the event, since so many students, they may have so many questions. So would you like to have written question, or they can ask directly?
They can ask me. I think that this would help me. I mean, I know that we have a limit of time. We have only 1 hour, right? I'm not hastened at all. I have plenty of time. So for me, it would not be a problem to extend this hour. It's okay.
Sir, so for convenience, either Tisha or any one of us, we can read out questions to you. Rather than asking participant to ask you directly, we will ask them to write the question in chat box. Tisha, either you, me, or Jubair, we can read it out to sir. Fine.
Okay, good, perfect. Wonderful.
Because, you know, it's better that we should decide the modus so it won't create any confusion when we are about to wind up the discussion. So, Tisha, I think we can.
Good evening to all present. I am Tisha, one of the core members of the ADR Cell of the University School of Law and Legal Studies, GGSIQ. And today, I would like to take this opportunity to warmly welcome all our esteemed guests, faculty members, and students in this international webinar on ICA Would It Ever Go Greener? Diversity, Inclusiveness, Sustainability, and Cultural Latitude in and through ICA, organized by the ADR Cell of USLLS under the guidance of our Dean Professor Dr. EP Singh Sir and faculty coordinators Dr. Vandana Singh and Dr. Zubair Ahmed Khan. Before formally commencing the event, I request all the participants to kindly switch off the videos and mute themselves in order to avoid any unwanted disruptions. ADR Cell is an initiative of University School of Law and Legal Studies, which focuses on instilling the practical skill in students. It seeks to provide an avenue for students, faculty, and practitioners to engage in research and discussion on latest developments in the field of ADR. Under the guidance of a Dean Professor Dr. EP Singh Sir and faculty coordinators Dr. Vandana Singh and Dr. Zubair Ahmed Khan, the ADR Cell has organized various webinars in the last few months and take immense pleasure in conducting this international webinar on this crucial field. Today, we also have Professor Jayesh Wood, who is a domestic and international commercial arbitrator and mediator with experience in US and Brazil. In addition to teaching corporate law, international law, conflicts of law, arbitration, and mediation for over 3 decades in top Brazilian and international law school, he is a specialist in development law and a master and a PhD in corporate law, holding an LLM degree in dispute resolution from Stroll Institute for Dispute Resolution from Pepperdine University, US, where Sir also teaches an ADR segment at the US Law, Legal English, and ADR summer seminar, and also has been appointed as ambassador in 2019. Besides being a research advisor at South Ural State of University, Russia, Professor is currently the president of International Editorial Board of ADR, Brazilian Law Journal, published by CEMA, Brazilian Center of Mediation and Arbitration, Rio de Janeiro, where he also sits as International Director of Academic Affairs. It is an honor to have you with us today. Now, I would like to invite Dr. Professor Vandana Singh Ma'am, Faculty Coordinator for today's event, for her welcome address.
Thank you, Tisha. Sir, we are having our senior professor, Professor Queenie Pradhan. She's a senior professor and Dean, University School of Mass Communication. She will welcome on behalf of ADR Cell and USLLS. Queenie?
Yes, Vandana, hi. Yeah. Okay, am I audible?
Perfect.
Hello. Hello, Professor Gewad.
Please.
On behalf of the University School of Law and Legal Studies, it is indeed my honor to welcome you to have this opportunity of listening to your lecture on a very important topic of ICA Would It Ever Go Greener? Diversity, Inclusiveness, Sustainability, and Cultural Latitude in and through ICA. ADR Cell is a very dynamic and a promising cell of the law school, which has been over a period of last 1 year contributing tremendously in ensuring that our students have a strong understanding and depth with regard to alternative dispute resolution mechanism, which is something needed in our country because of the heavy litigation and the areas of cases that we have. And I'm sure that we all will learn a lot from your experiences in the area of arbitration and in particular with regard to Brazil, how you have been taking up the challenges, which will actually help in reducing the pendency of cases and also ensuring that through the processes of alternative dispute resolution, we are able to mitigate some of the problems rising in our society. I really look forward to your lecture and I welcome you. Thank you so much.
Well, Professor Pradhan, it's a pleasure for me to be here with you. And I would like to congratulate your great university, Guru Govind University, your School of Law, all the provosts, all the faculty, as well as the students. Tisha, thank you for also representing the ADR Cell, having me in this event. Vandana, Zubair, all my dear friends from India. It's great for me to be here. And my only objective here, Professor Pradhan, is to somehow contribute to a discussion, to a more profound discussion of the subject, which is so important in our countries, right? And when I say our countries, it's a little complicated because right now I'm sitting in Brazil, but usually I'm in the United States and in some other places, Russia and so on and so forth. So this talk, I would not call it a lecture, right? Our talk today will focus basically on international aspects, international trade, international commercial arbitration, right? And instead of going too technical as to explain or to discuss cross-examination, for instance, or the extension of arbitration clause to non-signatory parties or this kind of subjects, Professor. What I'll try to do is to highlight some other aspects of this method, right? So I will not talk exactly about arbitration, but I will be dealing with it within the context of the international trade, Professor, because what I would like to highlight most of all from the beginning is that when we talk about international commercial arbitration, international, everybody knows what it is, right? Arbitration is pretty intuitive, right? It is a adjudicative method. It is a procedure, right? But when we talk about this commercial thing we are talking about, so, and I will just use here my PPT if you don't mind. Let me try to share this with you, right? Just a second. Okay. Now I'm sharing this. Are you seeing the screen?
Yes, yes.
Okay, I will try to go here. I do have a set of slides, and I will just go through them, not exactly in a specific order. So when we talk about international commercial arbitration, first of all, if you take the ancestral model law, which is in our screen right now, right? It says in Article 1, this law applies to international commercial arbitration. And exactly here at commercial, there's this footnote. And the footnote tells us that the term commercial should be given a wide interpretation so as to cover matters arising from all relationships of commercial nature, whether contractual or not. Relationships of a commercial nature include, but they're not limited to, and then it goes on describing all the content of this specific footnote. So again, Tisha, are you seeing the screen? Can I go on?
Yes, sir, you can, please.
Okay, fine. So here you have this, what commercial means, right? So commercial means basically, I'm sorry about that, let me get back there. Again, all relationships of commercial nature, any trade transaction for the supply or exchange of goods or services, distribution agreements, representation or agency, factoring, leasing, construction, consulting, and the list goes on and on, I mean, almost indefinitely. So what I'm trying to say here, Vandana, Professor Pradhan, Tisha, my dear friends, what I'm trying to say is that commercial means trade, trade means international trade, and this kind of trade is essential to humankind surviving. There is a whole supply chain in the international trade system that on one hand will have the producers, will have the parties, will be the will have the buyers, will be the sellers, and at the last link of this chain, we are going to have who? That very person that goes to the supermarket in order to get food to put on his or her table. Right? So when we are talking about the commercial aspect of international arbitration, we are talking about a system in which arbitration is one of the components, one of the compounds, right? And the whole production chain and the whole supply chain is all along this line. So what I'm trying to say here, and I will stop sharing for a little while, my friends, is that Tisha, Zubair, Vandana, Professor Pradham, when we are talking about international commercial arbitration, we're talking about a lot of things at the same time. It's like cutting a tree. It's like just managing a field where you plant a certain kind of food that you're going to need. It's like an ecosystem that has many different and diverse compounds, right? And that's the reason why, and let me get back to our slides right now. Let me try to share this once again. Okay, now I'm sharing this again. Okay, so you have here my name, my titles, and titles, let's be frank, don't mean much. And here we do have, I would like to begin this after clarifying what I understand about what the commercial aspect is and what international arbitration really means as one of the links of a big chain of facts, events, compounds and components, right? Let's just get some storytelling here just for us to, so imagine first of all, and I'm just kidding with you right now, right, that we do have this, oh, I'm sorry, let me try this again. Oh, there we go, right, okay, fine. It's complicated because, you know, it's not that easy. I'll try to stop sharing for a while and get back to the sharing thing. No, sometimes there are some technical problems, and okay, here we are again. Yeah, okay, because I'm not able to reach there. So imagine this happy family, right? They are located in London. John here is an accomplished arbitration lawyer at this big law firm in London, which is an upscale law firm, and he obviously wants the world to change for better. So John gets home Friday night, and he meets who? He meets his wife and his kids. He meets Susan, who is a very good lawyer too. But she's a mother of 2 children, so she opted not for working at a big law firm, but she was working for a public interest law firm, right? A kind of NGO which represents associations of indigenous traders of natural products, from which giant cosmetic and pharmaceutical companies take active principles to its perfumes, creams, and medicines. She also wants the world to change, right? And then you have also 2 kids, Rebecca and Ben. They are good kids. They're going to school. They expect the world to get better and everything, fine. And so John gets home and says, Vandana, he says like this, well, listen, Susan, I'm so happy tonight. You know what? We work at our law firm with a lot of papers and we are going greener now. We're going green in arbitration. Why? Because, for instance, I just eliminated all kinds of hard copies, right? So we are saving paper. We are not anymore having those long meetings at our headquarters. So we went totally digital right now. So this saves a lot of money. We are not anymore flying from to different places in order to have hearings. We are doing everything through a Zoom platform. I even laid down some of our assistants because you know what, we just outsourcing this work with a company in Uganda, so it's cheaper and everything. And so because of all of this economy, this savings that we are having and everything, we will be able, you know, Susan, to maybe go to Rio de Janeiro for vacations this time. Maybe we can visit beautiful beaches there. Maybe we can even go to the Amazon forest, right? Where we will be very happy. Just, you know, these images here show what we can do. And so John was so excited. John was so happy with that. And Susan, by her turn, said, well, you know what? Fine, I'm really happy and good. Let's do that. But the thing is, as you know, I work for those companies, I mean, indigenous companies back in Brazil. And I know that in arbitration, you were doing a lot of efforts to downsize everything and to save resources. But what really crashes me, what really impresses me, what really greets me is that when the contracts that we have, the agreements that we have with these companies, I mean, those giant cosmetic companies from Europe versus those association of native producers from Amazon, those agreements, they are so unjust. They are so unfair that the results in arbitration cannot be really sustainable, cannot be really inclusive, even when the native company, even when the indigenous communities, they win the case, the perspectives, I mean, the prospects are not that good, right? So, you know what, John? I don't know up to what extent going green is just about saving paper, saving electricity, saving international trips, saving hotel costs and everything, right? You might, of course, you might eliminate all those things here. You might eliminate the flights. You might eliminate the huge and fancy meeting rooms. You might eliminate hard copies. You might lay down people. You might use digital platforms. But John, up to what extent? And this is the kind of question that I would like to ask you here. Just a second, let me find the right slide. Shouldn't we be moving from a static perspective of going green in arbitration to a dynamic perspective by which sparing sheets of paper is important? But what about human lives? Saving kilowatts is great, but what about cultural traditions? Avoiding flies it's really wise, but what about avoiding extinction of traditional communities and ways of life, right? So, and Susan went on and said, well, according to the Green Pledge, because there's a Green Pledge, there's a green arbitration campaign going on, and it is good, it is fine. Carbon emissions are the metric, right? So we need to eliminate, Vandana, the carbon footprints of our activity as lawyers, as attorneys in arbitration, as arbitrators. Okay, but how many tons of carbon a human life is worth? Yes, because if you don't have fair trade practices in international trade agreements, which grants the surviving of a lot of people, you will be just losing lives. You will be losing jobs. You will be losing the firm bonds that holds a traditional community together. So Susan asked, how many carbon footprints the wiping out of a traditional community leave behind? Preserving the human, social, and cultural environment is not as important as avoiding trees to be chopped down. Wouldn't it be up to arbitration and arbitrators to be aware of this kind of frequent impacts that stemming from not so green trade agreements are spread out by and through pollutant arbitrations? So here's my point, my friends. Here's my point. Yes, it's important to save paper. It's important to eliminate, to extinguish hard copies of submissions, of proceedings. It is good to go online. It is great not to travel so frequently to Rome, to Amsterdam, to New Delhi, to Rio de Janeiro. Yes, this saves a lot of carbon. This wipes out, this erases a lot of carbon footprints. Good, wonderful. Let's keep doing this, right? But what about inclusiveness? What about diversity? What about sustainability? What about the cultural latitude of our agreements? Because again, Tisha, Professor Pradham, Zubair, Vandana, arbitration doesn't come out of nothing. You don't have an arbitration overnight. And every arbitration is a creature of a contract, of an agreement. There are no arbitrations without agreements, without arbitration clauses, without executory provisions that provide for arbitration. So arbitration begins like when you sail a boat, right, from one island to the other one. The journey begins when you set sail, not when you get there, right? So if you want arbitration to go greener, you need to begin very green. And when you begin green, when you start the first negotiations, let me give you an example, right? Just a second. So we are trying all the time. Just let me take this thing. Everybody has at home something like this. This is a huge battery, right? So why do I use this? Because I put my old batteries here in order to discharge them properly later. So it is beautiful, it is useful, it is great, but everybody knows that inside those batteries, we do have some heavy metal compounds, right? That if not properly discharged, will poison the soil, will poison the water, will maybe cause cancer for huge populations, right? So we need to be careful. So, and I'm careful as a person, as a human being. I put all my batteries right here, and when this is full, I just go to the proper place and I dispose of this. I'm sorry to tease you. I'm sorry to challenge you. I'm sorry to defy you, but let me just make a comparison. Wooden clauses, wooden provisions of international trade agreements be just like batteries? They might be fine, beautiful, well designed, but inside of them you might have a lot of heavy metal, right? So if I'm very careful when I handle a battery, shouldn't I be even more careful while handling as an attorney a contractual, a trade agreement provision that at the very end of this chain will turn out into an arbitration? Of course that I need to be careful about this. And my friends, This is all about what? This is all about, let me share my screen again. This is my screen. This is all about, my friends, being green. Are you seeing my screen? Are you seeing, Vandana, my screen now? Okay, good. So yes, we need to warrant functional diversity because it will be needed in arbitration later. We need to warrant functional inclusiveness, functional sustainability, functional cultural, and what is functional diversity? Diversity is a concept in our minds. It's an abstract concept. It's a brain content. But when I put it in practice through negotiations, throughout the whole cycle of the negotiation, execution, carriage of goods, transportation of the goods, even when the conflict arises, then it will be diverse, then it will be really inclusive, then it will be sustainable, right? So what I'm trying to say here, my dear friends, and I'll stop sharing for a little while, is that Tisha, Vandana, Zubair, Professor Pradhan, if you look closely, agreements, international commercial agreements, they are designing tools. They create an ecosystem of that specific deal, of that specific arrangement, beginning with negotiation, execution, performance of the contract, conflict, and so on and so forth. The lawyers that had drafted that contract, that agreement, have the power, and that's where, Tisha, ADR begins. ADR doesn't begin when the conflict arises. ADR begins when I first begin drafting the clauses, when I first sit with the other party to negotiate agreement. There we need to provide for a sane, for a healthy, for a green ADR process to be possible in the near future. Why? Because conflict is natural. Conflict will happen. And it's just not enough to think about the conflict when it comes out, because the conflict was generated, was conceived, was contaminating the whole process since the very beginning. It is like discharging this. It is like recycling water. It is like putting waste in the right garbage can, right? You need to dispose things very carefully. We have to wake up green in order to go to sleep greener, right? So the concern about the environment, and I'm not talking only about the material, the natural environment, I'm talking about the social environment, the cultural environment, the human environment, the business environment must be constant. The concern about this must be, ever present. And that's what I'm trying to say here, and allow me to once again share the screen. This diversity, if not functional, is just a concept. Inclusiveness, if not functional, is just an idea. Ideas are good, but ideas don't change the world. You need to act. We need to think globally, Vandana, and we need to act locally. If we don't act, it doesn't matter. It will not help. I can have a wonderful environment in my head, but when I go to reality, this might not really exist, right? So we need to be cautious. We need to be aware of the implications of going green in all different steps and phases of the international supply chain, modeled and designed by international contracts, by the international trade. So that's exactly where I want to get here. So allow me, I'm a great admirer of India. India is a great country. and I don't want to touch any political sensitivity here, but it's out of question that Gandhi is and was a great figure. I mean, he was or he is an asset to humankind, not only to India. And there was a point in which international trade with the British at that time, with the English guys at that time, I mean, was very complicated. Why? Because India had to pay a very high price for clothes that were manufactured in the UK, in Great Britain, right, in England, but the raw materials were produced in India. So it was extremely unfair. And instead of making a revolution or what Gandhi suggested at that time, he suggested a boycott of foreign clothes, right? Not through picketing, not through fighting, but through a non-violent use of the khadi. I don't know if I'm pronouncing correctly the khadi. I mean, the weaving machines, the weaving devices, and it was extremely effective. What I'm trying to say here is how much green was this? Was Gandhi talking at that time about international commercial arbitration? Of course not, but he was. Was he trying to interfere into the provisions of international agreements between India and England? Well, not exactly, but yes, that's what he was doing. And because of that, the boycott at that time was, of course, it costed a lot. There were a lot of different events surrounding this specific issue, but it was very successful in many different ways. So how much green, how much diverse, how much inclusive, I mean, functionally inclusive, how much sustainable was this, the language, the international trade language that Gandhi and his supporters were talking at that time to the world? Wouldn't this be a very good example of how to go greener in arbitration, in international trade, in negotiation? Well, was there other way for the British to understand the message at that time? Okay, nowadays we don't need any more the boycotts, right? Nowadays, we are very much, and this is an informative part of this talk. Nowadays, we do have here, for instance, just let me give you this. This is important. We do have here a campaign for greener arbitrations. So there's this amazing lady, her name is Lucy Greenwood, that from 2019 on, she championed this initiative that aims to reduce the arbitration carbon footprint. Oh, this is the term that we are using right now, the carbon footprint. So going green is to eliminate, it's to reduce our carbon footprints. Okay, fine. By what? Encouraging the management of arbitrations in an environmentally friendly manner, promoting awareness of the environmental impact of arbitrations, producing best practice guides, reinforcing the message that everyone is responsible for reducing the carbon footprint of this industry, and creating a workspace with reduced environmental footprint, corresponding electronically, encouraging the use of video conferencing, avoiding printing, using where possible suppliers and service providers who are committed to reducing their thing, okay, and so on and so forth. Fine, and the results are really amazing, because if you look at the carbon footprints of typical arbitration, you will find that, for instance, in this specific case here, there are a lot of carbon emissions that might be significantly reduced, right? So the figure relating to energy is based on the number of fee earned hours recorded on the matter, and so on and so forth. Okay, so what I'm trying to say here, my dear friends, Zubair, Tisha, Vandana, Professor Pradhan, and all the other members of this very selected audience, is that yes, let's stick with Lucy Greenwood and let's try to make our arbitrations greener as far as paper, electricity, flies are concerned. Fine, good. Let's not disencourage this kind of initiative. But can we go a little further? Can we look at this whole arbitration chain? Arbitration is the last link of this chain. Can we look at this more broadly? Can we look at this from a more inclusive, diverse, sustainable, cultural, friendly way? Shouldn't we be more concerned with what we are really doing for the social, economic, anthropological, cultural environment, along with beautiful forests, beautiful parks, beautiful, you know what I'm meaning? Are you getting what I'm trying to say here? So can we go even greener when arbitration, when international commercial arbitration will get even greener than it is right now, right? So in here, I would like to get to this point here, right? Which is, what is a greener approach in international commercial arbitration? Again, it is like using and disposing a battery. We lawyers, we arbitrators, we business persons, we need to be very much aware that going green begins when we first sit face to face with the other party, and we begin negotiating the agreement by granting fair opportunities to all stakeholders, including the international organizations, final consumers, the concerned sectors of civil society, to stake their points throughout all phases of the trading relationship, including negotiation, execution of the agreement, performance of the agreement, and eventually and occasionally adjudication of the agreement. Going green means to encourage the adoption of ethical sourcing codes of conduct. Because, my dear friends, what is Tisha? What is Zubair? The very early origin of the product that you ate this morning, of the food that you are going to eat tonight. What is the source? How that specific item was produced? Where all the intellectual property over that specific thing duly paid by the people that appropriated that thing. For instance, ladies, when you wear or use a certain perfume from Chanel, Dior, or you name it, I'm not really familiar with that, right? Are you really concerned if that specific essence, if that specific genetic asset that is in the very stemming of that fragrance, that thing was duly paid to the Amazon Indians, I mean, sorry, to the Amazon Aboriginals, to the Amazon indigenous guys that had produced that thing according to traditional ways, to traditional knowledge, to traditional customs. What's the importance of this? The importance of this is to the extent that the big companies don't get to an agreement with these communities. These communities will little by little, step by step, disappear. People will get sick. People will die. Okay, so we're talking about perfumes right now. Let's talk about vaccines. Let's talk about pharmaceutical compounds. Let's talk about pharmaceutical active principles that people desperately need in times of pandemic or not to stay alive. Imagine that for COVID, for instance, there is a specific plant, there is specific vegetable species in India that might be miraculously effective. Okay, fine, let's use this. But what about the people that had generated the knowledge that turned possible to us to use that active principle? Are they getting paid? That's the thing. This is the name of this is ethical sourcing, is the ethical handling, the ethical management of this property, right? So not only as we did with the green arbitration campaign, we do have a code of conduct. We do have best practices. We do have guiding principles. Right? We do have protocols. Why don't we do have protocols, guiding principles, codes of conduct when it comes to negotiating with living people? So being greener, going greener means to encourage the adoption of ethical sourcing codes of conduct, guiding principles and best practices, which will grant protection to the core interests of the most vulnerable suppliers. What interests am I talking about here? I'm talking about the interests of surviving, the benign interests of surviving, in which I want the industrial communities, the industrial environment to thrive, and I want the traditional environment to thrive as well. So a greener approach is one that employs fair, equitable, and mutually agreed trade and cultural practices, and aims to maximize diversity, inclusiveness, sustainability, and a culturally sensitive approach to all relevant issues. A greener approach is one that comprises fair negotiation and fair drafting of all agreements involved in that huge, long-lasting chain of events that begins when the product, the good or the service is put at the disposition of the buyer and ends when arbitration, for instance, renders its final award on a specific conflict, right? So fair negotiation, fair choice of ADR resources, is including step procedures going from negotiation to arbitration or litigation, as well as mixed ADR modes, mixing and matching. Here, my dear friends from the ADR Cell, I would like to ask your attention to the fact that the circles of conflict that will end up in a huge conflict, either in arbitration or mediation, it's like waves in the ocean. They begin very small and they go on and they grow and they grow, but the stem, the seed of the conflict, my dear friends from the ADR Cell, was already there in the very beginning if we were aware enough to notice it. So to be ADR friendly means to be able to see those things from the very beginning. It's like when you go to a doctor. Sometimes traditional doctors in China or in India, they will look to your tongue. They will examine your tongue. They will examine your skin. They will look at the way you move. They will look at your eyes and they will say, listen, I'm sensing something. I'm noticing something. I'm feeling something here. So let's try to, health is something that you need to prevent and care about from the very beginning. You don't go to the doctor only when you're sick, because when you're sick, you're already sick. You need to go to the doctor before getting sick, right? And the same thing happens with ADR. And this is green. We need to be concerned with nature, with our forests, with our animals, which are being extinguished before they get to the edge of extinction. We need to promote, diversity. The same thing happens here. It's not difficult, my friends, right? It is the right. So to have a green approach is to take care of the conflict before it even begins. It's not difficult to understand that those communities that give us such interesting products and everything, they need to be protected, because otherwise the industrial community, the industrial society will go there and finish the thing, right? And we don't want this to happen. So that's the going green that concerns me the most, because it's not difficult to understand that, if I don't print too much paper, I will be contributing somehow to the environment and everything. This is easy. The problem is to identify, the pollutants into a toxic business relationship. That's where ADR needs to be, the inception of ADR is, right? So again, we need to look for the adoption of an equitable benefit sharing policy, where only on those green agreements, no, in every single agreement, we need to be more benign. We need to act like Gandhi, right? We need to be nonviolent. We need to be assertive. We need to be very firm in our principles. We need to defend the interests of our clients at all costs, but not at the cost of violence and extinction, of depletion of the business environment, right? A green approach encourages mutual independence, growth, and capacity building, most of all, especially in favor of the most vulnerable party. It's one that promotes and generates social funds and benefits, that respects, preserves, and prohibits the unlawful appropriation of traditional knowledge and genetic assets owned by the most vulnerable party. It is one that respects and preserves culturally relevant and traditional ways of living and prevents social harm. So let me give you some examples, right, of what I'm talking about. And of course that now I'm using examples, my dear friends, that come from this clearly in green business, right? They are applicable all along the spectrum, right? They are applicable everywhere. But I'm just bringing these examples. Why? Because they are easier for people to understand, for people to see. So this case here, for instance, there are two different companies, Cosmetic Valley from France and Nativa from Colombia, right? And those two companies, right, Cosmetic Valley, of course, it's a cosmetic industry in France, and Colombia, Nativa Colombia provides essences, active principles, and natural products for this cosmetic company from Europe, right, from France. So they share both both parties shared some sensitivity about the sustainable use of biodiversity. And again, this is a quite easy example, but it might be extended to other situations. As well as the export readiness of Nativa and their interesting and innovative products. So they worked on an exchange of technology, know-how, and experiences on competitiveness clusters. As a result of this partnership, members of both organizations have gained access to a broad number of Colombian and French companies, laboratories, and research organizations. Right, so this is on a report. You have the source here of the Convention for the Biodiversity, for the Biological Diversity. You can find this at this specific site, right? And that's what I'm talking about, right? If you just want to take advantage of that indigenous community that has been producing green ingredients, genetic assets, traditional knowledge on the extraction of essences, you might do that. Those guys back in Amazon, they are starving to death. They are under extinction. They are really in bad shape. Even though Brazil or Colombia or we are, I mean, rich countries, those guys, they are poor. It's like maybe in India, in other parts of the world, you have rich countries with poor communities, right? It's not complicated to take advantage of these guys. It's not complicated to rip them off. It's not, especially, you know, you have a degree from Harvard, you have a degree from Guru Govind University, you are very experimented, you know how to negotiate, you can go there and just rip them off, right? It's there. We can cut as many trees as we want. We can just dispose our garbage, I don't know, everywhere. No, it depends on us. So that's what I'm trying to say. So this company, I'm not saying that Cosmetic Valley is a wonderful company, but they made sense that it was beneficial for everyone to get to an agreement, not at the end of the chain, but at the very beginning of the chain with the Nativa Colombia, in order to build up capacity, in order to exchange managing assets, exchange knowledge about the thing. And this has everything to do with ADR, Tisha. ADR is not only when the problem arises and then you have to deal with it in mediation or arbitration or mixing modes or whatever. This is where ADR begins, when we cooperate to avoid conflict, right? So this is an example. Let's get to another example, if you don't mind. Because of this is just a table that shows the results of this relationship between those two parties, right? So Cosmetic Valley learned about interesting products derived from native biodiversity, while Nativa facilitated access to potential buyers and pool of experts. This is a win-win thing, right? So while Cosmetic Valley, a complementary product offer for the Cosmetic Valley cluster, Nativa learned how to develop a competitive cluster for the cosmetic sector. Whereas Cosmetic Valley facilitated access to Colombian companies and research organizations, Nativa created possibilities for the training of its members in universities and training institutes, and joint activities were implemented and everything. Another example is the AAK Swedish-Danish company, which is a Europe leading producer of shea butter, right? So they acknowledge that there were a lot of pressure from consumer groups, non-governmental organizations, and government to incorporate ethical sourcing. And after a while, they did so. They required for every company that do business with them to adhere to adopt a code of conduct, right? As for sustainable and equitable sourcing practices, right? Natural ingredient suppliers should be aware of this trend and be prepared to provide traceability and information on the origin of their raw materials. So that's what those guys from the, I'm not saying again that they are wonderful, that they are the best in the world, but they certainly are doing something to bridge this gap in terms of greener practices. In Brazil, we do have this Beraca example. Beraca is a Brazilian company, one of the largest producers and exporters of natural ingredients from the Amazon rainforest, right? And they are working with heavily with ethical sourcing projects with indigenous communities and has adopted various sustainability schemes for its raw materials. So there's this partnership. So the source, again, it is the same source. You can check online afterwards. This is very, very interesting. So, and on the other hand, you do have this Supreme Court case, which is Avida. Avida is an American cosmetics company that was never really scrutinized for utilizing Indian knowledge for corporate gain. Right. So basically what they did what every cosmetic or pharmaceutical company had done over the years. They just go there and instead of paying for a traditional knowledge, instead of paying for the intellectual property, instead of building capacity with their partners, their more vulnerable parties, they just went there and somehow took advantage of those people, right? And this was brought, and this is only famous because a quite famous rock star in the United States, this guy here, let me show, Robbie Romero, right? A famous Apache rock musician, just meddle into the whole thing and try to negotiate with the indigenous people for sharing their knowledge. So what actually happened is that in 2006, Avida launched a product. This case went to the New York Supreme Court case, and but Avida, as far as I know, here the source is the book written by an Indian author, Nirmal Sengupta, Traditional Knowledge in Modern India, Preservation, Promotion, Ethical Access, and Benefit Sharing. And according to this source here, the whole thing went south, and the native people didn't get compensation, and there's this lawsuit, which I don't know exactly how it ended up, right? Just a second, Suresh, I will talk to you in a little while. So this is, my friend, what my message is now. Right? Before going to the question, right? To the questions. Yes, going green is very important. There are many ways of going green, right? This ecosystem model that we can very easily see in nature, in forests, in parks, in the ocean, in the desert, in the many different biomes, in the very different ecosystems that we have in the world, right? The savanna, or the tropical forest, or the rainforest, or the subtropical forest, or whatever. This is a model, this is a template, this is a platform that somehow might be replicated to analyze and approach pretty much all the problems in the world, right? Including how we practice law, including what we do from the moment we wake up to the moment that we go to bed to sleep, right? And what I'm trying to say is that going green is, of course, diminishing the carbon emissions, sparing paper, not employing too much, and saving kilowatts and electrical energy and everything. But much more than that. Going green means to provide for a healthy environment since the very beginning of a cycle. It might be an agreement cycle, a trade agreement cycle, a divorce agreement cycle, whatever cycle we are involved with might be provided to be greener if we pay attention to inclusiveness, diversity, fairness, conscionability, justice, equitable practices, cultural latitude. We need to understand each other, and we can do this and still getting money. Because you know what? It pays off. It gives you money if you do things as they had always been done. You will get bonuses, you will get promotions, you will get more fees, you will become a senior partner at a huge law firm in London, New Delhi, Rio de Janeiro. You have your room with a view to the ocean and everything. The problem, Tisha, the problem, Vandana, the problem, Professor, I'm sorry, Pradhan, is that behind your building, some miles from your building, people are starving. Not only speeches are being extincted, but people are being extincted, right? They are dying. They are hungry. They are not in good conditions. And this has everything to do, not only with climate change, not only with how much paper I spend, how many hard copies I print. It has to do with the way, ultimately, with the way that I negotiate, sign, perform, and adjudicate our international trade agreements. So let's go greener. Let's stop this talk right now. So whatever question you might have, I'm here ready to respond. There were some hands that had been raised. Please, Zubair, Tisha, Professor Pradhan, my dear friends here, but unfortunately I cannot nominate each one of you. So thank you for your patience, and I'm here to respond any question, criticism, whatever you might have to, give me back. So it was my pleasure. Thank you very much.
Thank you, respected sir, for such an informative and interactive session. Hopefully, all the participants have become more aware about the role of inclusivity in ICA and a broader meaning of going green by now. So now I would like to invite all the attendees to put forward any questions they have in the chat box. So we have a question.
Go ahead.
Question says, studies show that 90%. May I continue, sir?
Okay.
Yes, please.
Sorry.
Please continue, Tisha.
You can continue. Yes, please.
Studies show that 90% of all international contracts are already being governed by an arbitration clause. Then what else needs to be brought up? I mean to ask, are we aiming to make it 100%? Is that possible?
Of course, it's possible. But with all due respect, I don't think that being possible is all, right? There's an old saying about arbitration that one arbitration, I'm talking about the international level, right? And I would like to be very respectful to the way that you practice back in India arbitration, domestic arbitration at a daily basis. There are cultural differences here, but as a general rule, this old saying goes like this: an arbitration proceeding will be as good as the arbitrators that are in it, right? There are no miracles here. Arbitration, my dear friend, I don't know exactly how to pronounce your name, so but probably is Kushi Komari, right? Arbitration begins. It's not enough to have an arbitration clause. You need to have a good arbitration clause, because if you don't, this will be a disservice. It will come in your detriment. It will come in detriment of the parties. I'm the international director of a very important, and I'm not trying to brag about my importance over there, but it is a huge, I'm humbly working to cooperate with this chamber, ADR chamber, ADR provider in Brazil, which is the Center for Mediation and a Brazilian Center for Mediation and Arbitration, CBMA. And I hope to host you at any time back in Rio de Janeiro when the pandemic ends. So, and what I see there is that it is not enough to get contracts or business people or parties adopting our arbitration clause in their agreements. We need to see if this business will go well with arbitration, because as you all know from the ADR Cell, arbitration is only one possibility. Litigation in court sometimes might be strategically important for some business people, for some companies, and would maybe bring more benefits than mediation. Then some people are not, I mean, some companies are not prepared yet to mediation or to arbitration. So having 100% of the international trade agreements or international contracts with a arbitration clause, it might be good, my dear friend. But sometimes we are seeing, and I'm really working a lot with this Singapore Convention, International Commercial Mediation. And there are some problems, my friend, that only mediation can deal with. Let me give you an example. Imagine, so Brazil is a great seller of animal products to the Middle East. Right. So people from Saudi Arabia, from some other countries of that area, they procure meat packing products from leading Brazilian companies. But the problem is that those countries, they are mostly Muslim, right? And the meat that they consume must be processed according to certain and specific rules, religious, very respectfully, I'm meaning this, religious rules, right? If you have an arbitration clause, you need to have a choice of governing law for conflicts that would encompass, that would somehow admit adjudication according to the Sharia law. And this is very complicated. Why? Because in Brazil, Sharia is hardly known as a religious rule, let alone as a legal source of possible solutions. So these cases, my dear friend, international trade cases in which parties are very much unbalanced in terms of tradition, culture, and everything, these cases just cannot be solved. I mean, in a satisfactory token through arbitration. Maybe mixing modes, mediation, international mediation, plus international arbitration. So again, studies show that 90% of all international contracts are already being governed by an international clause. Okay, fine, this is good. 100% would be better. I would say that 100% of the contracts should have a ADR provision which was really thought of, which was really thought thoroughly, which was thought from the beginning to the end of the cycle in order to satisfy the needs. And again, as a director of an ADR provider chamber, I'm very much concerned on how much the clients, the users of the clause, are really aware, are really making sense of the consequences of adopting that specific provision or clause.
Thank you very much, sir. There is one more question.
Go ahead.
We talk about bringing up the concept of arbitration in making our ecosystem greener, then what exactly do we expect? Because things like Green Pact are already being taken up into consideration, specifically between India and Rome. And further, as sir that you have mentioned, that even after winning, they don't get whole justice. So there should be specific clauses for greener arbitration contracts only.
Well, again, 1 hour, it's a lot of time, but sometimes it is not enough time to go through the whole spectrum of cases, right? I've been talking about a casuistry. I've been talking about a selection of cases. I've been talking about a set of cases that were chosen to illustrate my point, right? And my point, and of course, that I used the most appealing, the most impressive cases, right? What I'm trying to say is that you can go green in any possible situation, right? Of course, then that when you are dealing with an international trade agreement between a traditional partner back in the Amazon basin, in the rainforest, in an European giant cosmetic company, you will need to be very wary, to be very ginger, to be very careful with the way that you draft this contract. The parties are very much unbalanced, right? So there's a need for capacity building. There's a need for educating, to sharing the benefits of the equitable sourcing of that specific merchandise or whatever. Okay, so, but we can be green in any kind of international trade contract. Maybe the wiggle room for you to adopt more benign, more equitable, more conscionable, more fair and just practices would be in certain contracts. The wiggle room will be a little bit smaller, right? Anyways, if you have 10% of wiggle room, you have to apply 100% of effort to make that contract, make that agreement work. The thing that you have to bear in mind, if I would say something to, my fellow colleagues, either students or would-be lawyers, is the following. You look to the international trade agreement as a designing tool. Every single clause, every single, again, Tisha, Zubair, Vandana, Professor Pradhan, I have a lot of friends who are transactional lawyers. They work with contracts and they feel very good. You know what? Because drafting a contract, drafting a business contract, it is like playing God. You are just saying things, you are just designing, you are framing, you are shaping business relationships that will actually be performed in the future. So you are somehow creating templates of behavior towards specific teams, specific situations. Okay, so that's why they are so happy. They feel like they're God, they're creating, they are designing, they are just modeling situations. It's like a video game, I would like to do that, to have a video game called Playing God. So you create the world, you do things. So, of course, I'm joking, but take advantage of this, right? When you create the ecosystem of that specific international trade, as a lawyer, as an attorney, pay attention to the underlying situation, to the most frequently not perceived situation. Go to the bottom of that situation, get into that commercial relationship, and try to design your clauses, arbitration clauses, performance clauses, liability clauses, price clauses, deadlines, everything, step clauses of negotiation when a conflict arises. Try to act as to make it green, create the world of that specific contract according to benign and smart things. Okay, is this going green? Yes, this is going green. So Gandhi went very green when he noticed that no contract, no agreement would solve the situation with the British at that time. And the only solution was a boycott. Instead of fighting, instead of writing clauses, he just sat down and worked by producing, by weaving fabric, right? And that brought the British to their knees, and they had to be more benign, to be more fair, and they made money. Not exactly. They stopped. Well, they didn't stop, but the abuse was diminished somehow. The situation had gotten a little bit better, or a lot better. So what I'm trying to say is that going green has to do with the nature and how deep the stakeholders, the buyer, the seller, the interested community. So there are different circles of conflict, circles of stakeholders. This is important, Tisha. And I'm at your ease for speaking about this other times, if you dare invite me, because, I'm just abusing your patience right now. So you will probably not invite me anymore. But anyways, okay, if you want, I'm at your ease. The thing is that, so try to first look at those circles of conflict and try to address them into your drafting, right? Try to be more benign. This doesn't mean Gandhi was very much assertive, was very much effective, but he was not violent. Am I audible now?
Yes, you are audible.
Okay. Fine. Okay, that's basically it. I don't know if I responded to the question by, green business or green agreements are easier, but not so green might be also dealt with in a green manner.
Okay, Professor, I am having a simple question. In fact, I'm asking your observation. What I have observed in last 1 decade, that we are talking about ADR, we are talking about promoting of ADR, but arbitration by its nature, by its cost, by its international agreement and contract, we are making it for class and not for mass. So what is your observation with respect to arbitration specifically? Like the common people, they are not able to relate themselves to arbitration. So what is your observation?
My observation, first of all, Vandana, is the following. Usually people look at arbitration as a very benign way of doing things, and this is not true. If you go to the United States, for instance, and if you open a banking account, right, you will have to sign either you like it or not, an agreement by which all conflicts will be subject to arbitration in a specific chamber, according to rules that you cannot control, and you'll be very probably ripped off in this specific arbitration procedure, right? So arbitration, as everything in the world that we live, might be used for the best or for the worse, right? That's the first thing, okay? So access to justice, access to a fair system of justice is a huge problem in many different countries, not only the so-called developing countries, but also in the developed countries, right? One of the reasons why mediation is so popular in the United States is that litigation is so expensive and time is so short that people cannot afford to either spend money or time discussing a case. So they go on and they settle it in 10 minutes because it would be easier, even if the solution is. So can we say that in the United States you have free access to justice, that it is good? And in India we don't, because people are not accustomed to arbitration. So that's the thing. Conflict is something that we need to tackle in its very causes, right? So discussing conflict is already important. So when you bring this population that don't have enough information to deal with this arbitration thing, when you incorporate these guys, these populations, these communities, to the other benefits of a just society, I mean, health system, food, education, they themselves will tell you how to solve their problems, how arbitration can be adapted to serve them as a system of dispensation of justice. So what to do? There's no miracle in them. There's no simple way of addressing this. You have, for instance, tell me this, if it was not for the colonization phenomenon, would India, which has millennia of civilization before the Western civilization was even born, we were living, I mean, white people, not Indian people, I mean, Europeans were living in caves, and India was already, you know, a very beautiful civilization and everything. So how do they manage to solve their justice problems at that time? So the solution might not be arbitration, something in between. So that's why, Tisha, I'm a very huge fan of the mixing modes. For instance, you probably have already heard about restorative justice. Restorative justice. So, Vandana, before looking for the adjudicative method, look at the conflict. What kind of conflict they have? What causes that? What are the causes of those conflicts? And then you will look to the solution. We cannot, because, you know, Vandana, let me just tell you this. What statutes are in Europe, I mean, in Germany, in Brazil, in some other places, in civil law countries, we work with codes, not statutes, not precedents, right? So what are statutes but collection of conflict templates that you have to deal with? Is like, for instance, if you're sick and the doctor does not know exactly what you have, what he will say, well, he has. So in the civil law societies, they first invented the solution to your conflict. So we should not do that. We should first look at the conflict, see what are the circles of conflict, and then eliminate the causes. It might be through an arbitration-like procedure. Does the Indian culture rely firmly into respect to the elders, respect to the judge, respect to the arbitrator? Good. So this is something. But how this thing will function, right? But look at the cause, look at the culture, and then you provide to arbitration. Again, I'm not in favor of cramming down people arbitration solutions. Is that what they need? Is arbitration by chance a miracles tool? Sometimes not. It might be used for not for the good, greater good of people. I don't know if I'm responding your question, but the same thing. That's what I do when two international companies come to CBMA, where I'm an international director, and ask me, should I adopt the CBMA arbitration clause in my agreement? And I will say, it depends. It depends, my friend. What is the nature of your relationship? What are the biggest red flags for conflicts? What are the usual problems that you have? And then I'll tell them if they should come with us in Rio de Janeiro, or maybe ICC would be better for them. And maybe, jams in the United States would be better for them. And maybe no arbitration clause, go straight to litigation. It's more important to focus on the governing law. Are you getting what I'm trying to say, Vandana? I don't know if I'm being clear enough. But again, I don't have your answer. I don't have your solution. But I think that we need to look, if you want to find a medicine, look at the disease. But not the disease as a template, as an abstract. Look at the sick person. And then you might find the medicine. That's basically what I have to tell you.
Tisha, I think there is no other question.
Now, I would just like to say that thank you very much, sir, for addressing all the queries and now with such in-depth clarity. Now, I would like to invite Dr. Zubair Ahmed Khan, Assistant Professor at USLLS and Faculty Coordinator of today's event, to extend our gratitude and deliver the vote of thanks. Over to you, sir.
Okay, just a question, just another observation. Whatever question you might have, I will send to you through email my email address. And please, you can reach me at any time through LinkedIn, through Facebook, and through my email address. Send me your questions. I'll be more than happy to respond them. I cannot promise that I will do it tomorrow, but in a week's time or 2 weeks' time, I'll do that. Right? Thank you very much. It was my great pleasure. I'm eager to listen to our professor that will give the farewell speech. Thank you, my friend.
Zubair, Professor Vani is also there. Sir, Vani sir?
Professor Vani sir, are you there?
Yeah, I'm here. Yeah.
Yes, sir.
Okay. It's I had to be there because you are there. So, and we have to be there when you are there. Do you want me to say something?
Yes, sir. Just
I would say Professor Jer, he made a very wonderful presentation of thoughts, I should say. Basically, what we are endeavoring now at the national and global level, that we should create some harmony. All these ADRs and then ICA or any mediations and all other things, we should have that everybody in the world must feel that it's not necessary to go to the court of law, and it's not necessary to have the conflict when it is in birth, as Jair was saying. It's not necessary to wait that it should result in a sore and then we go to court of law and then try to settle it. Because the conflict at any level, even at the time of birth, we can look for them. And that's how I would say that we have to create a temperament and then appreciate. And then I would say that we do have a spectrum of them. But there can be, as we are in the habit of saying, sui generis mechanisms which must be existing in different cultures, in different regions, in different localities, with the support of their literature or with the support of their mentors, as talking of Gandhiji. So we can have overall in the world a kind of inkling towards ADRs, and then especially negotiation, conciliation, and mediation and arbitration. I would stress one important thing, that mind should be trained to negotiate. Mind should be trained to conciliate, and mind should be trained to mediate. And then if need be there, then we may go for arbitration and then arbitrate as well. I appreciate professors' all version, but I believe that from their fora, now there is a need to project the development of overall. Actually, in any dispute resolution, we need that the parties must possess some equitable potential. And when at any level, we feel that there is lack of that potential, then definitely it does not result into a solution or resolution which actually we want. Saying thereby that it should not be a tussle, a fight to get more out of the conflict. It should be definitely to get some more fairer, just, reasonable, and appealing to the conscientiousness. And you may not say it's a mode of justice. You may say it's a mode of resolution, but that resolution should not be away from justice. And there we have to be, and I believe that all the world bodies.
Tisha, I guess.
I think the host is hostile to me, and so they mute me. I don't know. So mine is that unless all the global bodies which want arbitration and mediation and other things to be very popular, and they should be. Without them, we can't produce a harmonic society. And at the same time, what should be done in that? I think there is a lot to be looked into that and produce that kind of inclusiveness. Can we have true inclusiveness without creating some uniformity or equitability in their potential? So mine would be, this time not going into detail because I don't want to embarrass these hosts that way. Mine will be that at least the legal education must address this issue, and it should get better space in legal education in countries like India, where they can develop at least a better capacity in mediators and negotiators and in conciliators and in arbitrators. I would not talk of the judges, but definitely I can say that if there is any kind of hitch, any kind of obstruction that we are not able to popularize at all levels these ADRs, the basic thing is that our human resource for that is not possessing sufficient potential. And for that, the further reason is that it's not getting too much space in the courses, and it's not popularly being advanced through different training sessions, and probably the mind to be developed so that there is self-developing capacity. That opportunity is also not created that way. So that's how if any Indian is asked, the first thing that comes to the mind will be a writ of habeas corpus, mandamus, and other things, and that also in the civil matters, that also in other matters, commercial matters are like that, going to the court. And that's how I believe that there is a need that legal education has to address this issue, and then see that legal education's first thing must be, first target and first focus must be alternative dispute resolution mechanisms, their importance, their goals, rather than having focus as they have today about going to the court. And then when law is being taught in our universities in India, they only refer to the judgments of the courts. They do not refer to the sense of the law, purpose of the law, how law should function. At least law has a function even before going to the court, before making its use in the courts. So I think it should be the last reference, and that should be the last thing to be told to the student, that there can be a conflict sometimes, and when we can't make the law work or we can't make the system go, sometimes we may have to go to the court of law, and there are these experiences in courts. So the overall teaching that has to go differently, and I believe on to everything in this end. So I stop here by saying that equitable potential development should be at international level, among us the cultures, among us the people of the states and countries, and then at the national level in all who are there, not excluding even a single citizen. There should be some potential. And if one is not having, another person should stand there. And that's what legal aid can mean with respect to ADRs. That's what this is basically what we should have, and that thereby we can develop a harmonious society, and we can find the purpose of law being fulfilled. That's the main purpose of it. That's what I would like to say at the moment. Thank you. And it was, I again appreciate that you had shaped the presentation very well, and very well captioned, and then it had a good analytical approach. That's our students should learn that how to do it. And that also you are doing in this pandemic period. God bless you.
Thank you so much, Professor
Okay,
Vani,
thank
sir, for sharing your views. And sir has already expressed his gratitude towards you, Professor Jair. I like to, on behalf of my school, like to extend a very hearty vote of thanks to our chief guest, Professor Jair, also, who spared his time from his busy schedule to grace this occasion. Thank you so much, sir. Today we had an opportunity to hear your thoughts on various aspects, on a various holistic perspective of green arbitration, to what extent it can be connected with the functional diversity, functional inclusiveness, and the kind of examples we have shared with us, we can contextualize with the modern day arbitration and modern day mediation also. And I also like to give my sincere thanks to all my respected colleagues, Professor Queenie Pradhan ma'am, our Dean sir, who was not present due to certain issues, my faculty coordinator, Dr. Vandana Singh, my other colleagues, Dr. Ravinder, Dr. Gurjeet, who also supported us and be part of this event. I also like to give a thanks to my student coordinators, Tisha and Shambhavi, for arranging this an interactive session all together. And last but not the least, I'd like to give my special thanks to all the participants to be part of this event. Thank you so much.
Thanks, sir. We will look forward for more meeting.
Thank you.
So, my dear friends, God bless you.
God bless you.
See you around. Take care. Bye. Bye. Thank you.
Hope all participants have filled the form.
Yes.
Just ensure, then we can end the meeting. ठीक है?
हाँ ठीक है मैम। ईशा एक बार और शेयर कर दे एक बार।
I think everyone has signed now.
हाँ यस मैम।
चलो फिर we can end the meeting, right Jubair?
यस यस ठीक है टीचर।